This matter is listed tomorrow at serial number 1 and 2. Dr. Abhishek Singh used to appear. He is not available.
Interesting.
Yes.
हम return नहीं करेंगे.
Yes. He is only
आप तैयार हो जाइए.
He is only praying for second. Second of airport.
अब हो गया, बहुत हो गया. अब इतने सारे judgments भी आ गए हैं environmental issues पर. क्या हुआ? What happened? The state has done what?
From the state and few correspondences.
बस आप correspondence करते रहिए, पेड़ काटते रहिए, अपना इंडस्ट्री चलाते रहिए और यहाँ से सारा का सारा मिनरल लेके चले जाइए और पूरा डिफॉरेस्टेशन करके निकल जाइए यहाँ से. Every day is a loss.
No tree falling is being
No,
done since
not
last
falling, but without compensatory afforestation, you are continuing your industry. है ना? अभी सुप्रीम कोर्ट का ऑर्डर आया है ना नया, नहीं चलेगा, ऐसे हम नहीं कर सकते. एक बार और हम वेकेट किए थे.
Yes.
अब हम फाइनली डिसाइड करें. अब वेकेट नहीं करेंगे.
On 11th, but the leadership, since the bench was not available, he was virtually ready for that.
Will come physically or online? उनको बोलिएगा online ठीक से नहीं पता
virtually
चला.
itself, but all of a sudden it has come on 25th.
No, it has not come all
Yes,
of a
we have
sudden.
informed that it will come, but he said that.
All of a sudden कैसे ऑर्डर अपलोड नहीं होता है यहाँ पर? आप लोग अपलोड नहीं करते हैं ऑर्डर?
नहीं order. I cannot blame you.
इसलिए ये आपको मत
And it is
बताइए.
well known that
There is no case in this board which does not have a date.
Yes, I accept.
इसीलिए आप ये कैसे बोल सकते हैं all of a
I
sudden?
am only praying that his request is for second, if permitted. We are taking consent of the SGI also, and then only I will.
यही तो बात है. फॉरेस्ट के मामले में सबका कंसेंट है, लेकिन कोर्ट कंसेंट नहीं देती. मतलब दिस इज नॉट डन. दिस इज नॉट डन. उनके पास जमीन नहीं है, आप प्रोपोर्शनेटली जमीन खाली कर दीजिए. जितना एफॉरेस्टेशन किए हैं उतना भर रखिए.
More than that, we have already given.
No, what I need to say is प्रोपोर्शनेट करना पड़ता है ना. 1 एकड़ का इतना, जितना आपने
5
किया
times,
है,
3 times what they will say.
जितना आपने किया है बस उतना ही भर दीजिए, बाकी रिलीज कर दीजिए. अभी हमको पता चला है there is also a policy that other states are also offering land for afforestation.
But the state of Jharkhand will not permit that. We are ready.
Will not permit means what? दूसरे भाई जब झारखंड में आपके पास जमीन नहीं है देने के लिए, तो दूसरे स्टेट में एफॉरेस्टेशन करने दीजिए. कोई डिफिकल्टी नहीं है.
Yes, we will give. We will give. We are ready for that. I will.
अब हम फाइनली डिसाइड ही करेंगे इसको. ये हम लोग नहीं रख सकते हैं पेंडिंग. थोड़ा सा एनवायरमेंटली बहुत साउंड नहीं.
But still, I will pray that I will.
नहीं, I will give you time. 11 तारीख मतलब आज कितना तारीख?
Next Friday. Today is 25th. He is requesting for 2nd of next.
2nd of
May. Next Friday.
एक दिन में तो खत्म होगा नहीं. फिर 1 महीना का डेट लेंगे. नहीं ना होगा ऐसे. हम तो 10:30 बजे से सुनेंगे और तब तक सुनेंगे जब तक खत्म नहीं हो जाए. तो फिर नेक्स्ट डे ही विल नॉट बी अवेलेबल एंड आई विल नॉट बी एबल टू पोस्ट द केस ऑन द नेक्स्ट डे. फिर मंडे को बहुत बिजी रहेंगे. फिर 1-1.5 महीना का डेट होगा, तब तक हम सब भूल जाएंगे. ये कहानी नहीं चलेगी. थर्सडे को रखिए, फ्राइडे तक खत्म कर दीजिए. एक ही केस सुनेंगे. आपको पूछ के आइए. वी वांट 2 कंटिन्यूअस डेट्स. पूछ के आइए. पूछ के आइए. आपको पता है 10:30 बजे शुरू होगा. जब तक आप बहस करेंगे तब तक चलेगा. I know he is a busy person. Go and talk to him. Ask him that we need 2 continuous dates, one after another. Break नहीं चाहिए हम लोग को इस तरह के मैटर्स के लिए. पूछ के आइए कौन सा डेट सूट करता है.
Continue case item 14, second appeal 674 of 2016.
ट्रायल कोर्ट के जजमेंट को रेफर.
हाँ करिए. क्या रेफर कर?
केस 36
बताइए.
पैरा 23. पैरा 23
क्या बताना था?
टीचर्स 12-13 लाइन बॉटम। साक्षी ने आगे कहा कि हीरा महतो को उदयपुर मौजा की बहुत सारी जमीन थी, जिसको लेकर माननीय अवर न्यायाधीश धनबाद के न्यायालय में स्वत विभाजनवाद 573 अंशदारों के बीच चला, जिसमें ग्रामीण पंचों के हस्तक्षेप से एक समझौता सभी अंशदारों और पंचों ने मिलकर किया कि जिस अंशदार ने अपनी पुश्तैनी खतियानी जमीन को विक्रय किया है वह उन अंशदारों के अंश में ही समायोजित किया जाएगा। उक्त निर्णय के अनुसार स्वत विभाजनवाद का निस्तारण हुआ। साक्षी ने आगे कहा कि उसके पिता मनसुख महतो ने विवादित भूमि उसकी मां श्रीमती संजुआ महतानी के हाथ केवाला संख्या इतना दिनांक 7870 को विक्रय किया। उक्त विक्रय विलेख के द्वारा मौजा उदयपुर खाता नंबर 21 प्लॉट नंबर 2386 रकबा 23 डिसमिल मध्य 24 डिसमिल भूमि एवं अन्य भूमि विक्रय किए गए, जो स्वत विभाजनवाद में समझौता के शर्तों के अनुसार उनके पिता के अंश में छोड़ी गई और माननीय न्यायालय द्वारा जमीन को दिया गया। हमारे पास उसका एग्जिबिट 3 है। एग्जिबिट 3 में कॉपी है मेरे पास। इसमें कहते हैं कि जिसकी संपत्ति जो है उसी के अंश में रहेगी, जो बिक्री हो गया है उसके बारे में कहते हैं। जिनके जो बिक्री हो गया उसी के पास रहेगी। हमारा अगर 100 डिसमिल है, हमको हिस्सा में मिल रहा है, तो 24 हमने बेच दिया तो 24 मेरा कटेगा हमारे हिस्सा से और अंशदारों के बीच में बटेगा। वो 24 को लेकिन डिस्टर्ब नहीं किया जाएगा, यही था।
ये आपका प्रिलिमिनरी डिग्री है, ये आपका कौन सा डिग्री है? एग्जिबिट 3 आपका आर्बिट्रेटर का अवार्ड है।
आर्बिट्रेटर का अवार्ड है, वो फाइनल आज तक नहीं हुआ है।
क्या चीज फाइनल नहीं हुआ?
आर्बिट्रेटर का
पार्टीशन
फाइनल
सूट तो डिस्पोजल हो गया ना 73 का
जी,
कि वो भी अभी पेंडिंग चल रहा है।
तो उसमें कहाँ तख्ताबंदी कहाँ हुआ? आई एग्जिबिट 3 है, पार्टीज का सिग्नेचर है, सबका एग्जिबिट किए हैं सूट में। तो 24 हमारा ये नहीं कहना है कि 24 नहीं बटेगा, 24 के बदले में हमारे जो वेंडर थे उनके शेयर का 24 कटेगा। तो 24 कटेगा माने उनको अगर 100 डिसमिल था तो 76 में उनका बंटवारा होगा 1/4।
76 में बंटवारा 1/4 नहीं होगा
जी
100 में 1/4 बंटवारा होगा।
हाँ,
और अगर आपने
हाँ,
वो डिस्क्लोज किया होता कि
हाँ,
आपने उसमें से कुछ बेचा है तो आपके पास से 24 वो कट जाता, मतलब वो 24 आपकी वाइफ का प्रॉपर्टी आपके 25 में इंक्लूड हो जाता।
जी
ठीक है,
हाँ, वही बात था। और डिस्क्लोज्ड है इसलिए कि बिफोर पंचेज इट वाज डिसाइडेड, वो ऑल द पार्टीज हैव साइंड बिफोर दिस एग्जिबिट 3। वो उतना ही का है झंझट। चौबीस डिसमिल अगर हमारे पास रह जाता है, जैसा कि मेरी माँ के नाम से सेल हुआ और उसका म्यूटेशन भी हो चुका था और वो पोजेशन में आ गई थी, और बहुत पहले 1970 में, अब 73 में पार्टीशन सूट फाइल हुआ। पैराग्राफ 30 में है, पेज 39 ब्रदर से एक अवलोकन से प्रस्तुत होता है कि पंचायत को न्यायालय द्वारा संतुष्ट किया गया और उसे डिग्री का अंश घोषित किया गया, साथ ही साथ अंतिम डिग्री तैयार करने का निर्देश दिया गया, परंतु अभिलेख पर ऐसा कुछ नहीं है जिससे यह दर्शाता हो कि उक्त वाद की अंतिम डिग्री तैयार हुआ। स्टाम्प अधिनियम के अनुसूची 1 में अनुच्छेद 45 के अनुसार विभाजन विलेख पर
आप जरा फाइंडिंग ऑफ फैक्ट देखिए
जी।
In that partition suit, the land transferred through Exhibit 1 was not allotted in the share of Manshu Mehta. Not allotted. बताइए।
फाइनल डिग्री नहीं हुआ है।
हम नहीं जानते।
उसमें
there is a finding that it was not allotted in the name of Manshu Mehta.
ट्रायल कोर्ट की जजमेंट से पता चलता है कि अभी तक फाइनल डिग्री हुआ ही नहीं। Then lower appellate court how he has given the finding फर्दर से के अवलोकन से दर्शित है कि पंचायत को न्यायालय द्वारा संतुष्ट किया गया और उसे डिग्री का अंश घोषित किया गया, साथ ही साथ अंतिम डिग्री तैयार करने का निर्देश दिया गया, परंतु अभिलेख पर ऐसा कुछ नहीं है जिससे यह दर्शित होता हो कि उक्त वाद में अंतिम डिग्री तैयार हुआ है। स्टाम्प अधिनियम की अनुसूची 1 के अनुच्छेद 45 के अनुसार विभाजन विलेख पर विभाजित अंश के मूल्य के अनुसार स्टाम्प शुल्क देय होता है। स्टाम्प अधिनियम की अनुसूची 1 के अनुच्छेद 12।
You just tell us, as per Exhibit 3, what is the description of Exhibit 1? बताइए, what is the description of the property?
Exhibit
खाता नंबर,
खाता नंबर 21, प्लॉट
21,
नंबर
plot number
प्लॉट नंबर
2386
2386
and area
24 decisions out
24
of,
decisions.
out of 30।
What was the subject matter of partition by Exhibit 3? दिखाइए Exhibit 3। दिखाइए।
सब्जेक्ट मैटर ऑफ
आप हमको Exhibit 3 दे दीजिए बस। नहीं, ये तो award नहीं है। Where is the award? Award must have formed a part of this. Award कहाँ है? No. You see, you come to page number 8 of the appellate court judgment. आधा डॉक्यूमेंट हमको मत दिखाइए। Award must have formed a part of this.
इसलिए हम पढ़ रहे हैं
इसीलिए पढ़िए जरा।
कि
आधा डॉक्यूमेंट मत दिखाइए, हमको आदत नहीं है इस तरह से देखने की।
एक लाइन पढ़ दे रहे हैं हम, हमरा कहीं कोई ऐसा
देखिए,
मेरा कोई
कॉन्फिडेंट
intention-
फाइंडिंग है आपके एक लाइन पढ़ने
मेरा
से सब
कोई
सैटिस्फैक्शन ऑफ
intention
लाइफ।
नहीं है कि वो
हम
भी
आपके
करें।
इंटेंशन की बात ही नहीं कर रहे
जी।
हैं। हम आप पेज नंबर 8 में आइए, एपिलेट कोर्ट जजमेंट में।
हम ट्रायल कोर्ट के
एपिलेट कोर्ट जजमेंट के पैरा नंबर 14 पेज नंबर 8 में आइए,
जी
which says that during arbitration proceeding
Independency of state partitions parties will jointly file application to refer the matter to arbitrator of 11 arbitrator. The matter was referred by the court to the arbitrator during arbitration proceeding. Parties jointly filed petition dated 2/6/74 Exhibit 3. That is Exhibit 3.
अभी पिटीशन है एग्जिबिट 3।
हाँ, filed a petition.
आपका ऑर्डर शीट दिखाएं। वो इनकम्प्लीट डॉक्यूमेंट है, ऐसा नहीं करिए। आगे देखिए, दैट ऑल द जॉइंट प्रॉपर्टी
will be equally divided in 4 parts.
आगे बढ़िए।
The land sold by any of the co-sharer will fall in his share. इतना ही है मेरा।
आगे बढ़िए।
Further case of the plaintiff is that despite this petition before arbitrator partitioned the land pertaining to khata number 21, plot number 2386, area 33 decisions equally in all co-sharer, which is in violation of the agreed term of partition among the parties by the executive.
यही तो इक्वली शेयर आपका डिवाइड हुआ, which you say is in violation of the terms of the agreement.
Exhibit 3 is there. Exhibit 3 until date no final decree is prepared in 74 suit. इसमें आज तक नहीं हुआ है। तो जो मनसूख के हिस्सा में जाएगा उसमें से 24 डिसमिल कटेगा। इतना ही केस है, कुछ नहीं है, नथिंग एल्स। कोई मतलब फाइलिंग ही नहीं था। 1970 में बिका, 73 में जाके सूट फाइल हुआ।
तो ये
और भी-
स्त्रीधन का कहानी नहीं ना है?
जी,
क्या वो स्त्रीधन बन गया उनका?
तो
Now therefore, so according to you, I will record your submission. According to you, the property which was sold to your mother
yes,
should form an integral part of the share allocated to Manju. Correct? I will record that. Should I?
but that was
This is what you are submitting.
so that
This is what you are submitting.
so it was purchased by
We do not know. आपने यही बोला ना? The property which was purchased, which was transferred to the mother by your father, should form an integral part of the allocation of share to your father.
for the purpose of partition. But that property now, after execution of sale deed in the year 1970, that became her stridhan, because it is not the case of either party that it was purchased from the fund of the Mansub. Rather, it was purchased by her.
Now,
by
after the
his
death of the mother,
ma-
it will devolve upon the children only.
Yes.
So, how does that make a difference whether it is Tridhan or it was purchased by Mansukh Ram?
So it,
How does that make a difference? It makes no difference. After the death of the mother, even if it was her son, that will devolve upon her children.
only upon the children, not to any other co-partner or co-sharer. So that specific area, my submission is that specific area should not be partitioned. Rather, excluding that specific area, it be partitioned.
No, excluding नहीं होगा.
Excluding.
Including होगा, but that portion will fall
Yes.
to your father's share to the extent of 1/4.
वन वहीं पे इंच है, 1/4 हो जाएगा तो फिर हमारा कट जाएगा।
कट ही जाएगा ना. 33 डिसमिल का प्रॉपर्टी है,
हाँ,
24 डिसमिल आप बेचती है,
हमने बेच दिया।
तो 1/4 में क्या कटेगा नहीं?
सूट प्रॉपर्टी ऐसा नहीं था कि सिर्फ 38 डिसमिल या 33 डिसमिल का ही पार्टीशन है। सेवरल एकर्स ऑफ लैंड वेयर देयर इन पार्टीशन, एकर्स ऑफ लैंड in partition in 74 suit. Therefore, it was agreed between the parties. The person who has already sold and transferred, that will fall in his share. And in supplement of that,
ये जो पैराग्राफ 5 में लिखा हुआ है, according to the award separate allotment chart was made to each of the co-sharers. Where is that?
so that
Where is that? Where is the award?
the one final award is not given brought either by either of the parties. Therefore, I was
Final award is not exhibited.
No, it is not yet prepared.
No. Award means arbitral award. Where is that award? Award must have been exhibited. Exhibit. Award किसको बोलेंगे हिंदी में? Allotment of exhibit C is the allotment of arbitrators award. Exhibit C. लिखे तो पंकज.
But still it was not.
सुनिए, बिना रिकॉर्ड देखे हम इस तरह से आपके बिना समझे हम क्वेश्चन ऑफ लॉ नहीं बनाते. रिकॉर्ड मंगा लेते हैं, उसके बाद सुन लेंगे आप. लेकिन आपकी बात अगर गलत हुई ना तो अच्छी बात नहीं होगी, क्योंकि देखिए आप बोल रहे हैं कि आप क्या आप लिखा थे ऐसे नंबर 674 of 2016. The learned counsel for the appellant has submitted that the property covered by sale deed number 21295 dated 7/8/1970, consisting of 25 dismil of land out of 33 dismil in plot number 2386, but was sold by the father of the plaintiffs to their mother prior to filing of partition suit number
5 of 1970.
5 of 1973. In the partition suit, it was ultimately decided that the property will be divided equally amongst 4 co-sharers, and the property which has already been sold will be included in their respective share. The learned counsel has submitted that accordingly the property which was transferred by their father to their mother was to be included in the share allocated to their father. And consequently the property devolved upon the plaintiffs on death of their mother exclusively, and it would not go to the other co-sharers of the father. It is not clear from the in order to frame the substantial question of law involved in this case, this court is of the view that the records from the concerned court be called for. Let the records be called for. Communicate careers of it. Post on 11 June. Exhibit C देख लीजिएगा, उसी से क्लियर आप इतने देर से सुबह से बैठे हुए, आपका मैटर है। आप पास ओवर में आप लोग थे, कौन थे पास ओवर में? पास ओवर वाले काउंसिल नहीं, चलिए। You are there in this case?
Yes. Although Mr. Gupta had to argue this case.
Of although it's a
No, I'm not seeking a judgment.
Item 6, first April 15 of 2025.
काउंसिल जब बाहर से आते हैं तो आप लोगों को थोड़ा
No,
ध्यान
I will
रखना
just
चाहिए।
point one issue in this case.
क्या इशू है? ऐसा कौन सा इशू है जो नहीं हो सकता? सर्विस
Yes.
कंप्लीट है?
No, respondent number 31, she has died.
31 has died.
And she died during the pendency of the trial. So, an order was made for her substitution, but ultimately she was not substituted in the plaint itself.
I think you
No.
must make statement correctly. I have inspected the entire records and I'll apprise this honorable board.
Yes, please tell us.
Yes.
वो he has one objection.
I have, yes.
हम देख रहे सुबह से आप रिकॉर्ड देख रहे हैं।
Yeah, I have seen the entire record
ये must have.
and I am prepared with this. Lordship, what has happened that this respondent number 31, she is Noor Jahan Khatun. She died during the pendency of the suit in 2022. An application was moved by us for bringing the legal heirs on record. My application was allowed. Legal heirs were brought on record. She was proceeded ex parte when she was alive. The legal heirs also got ex parte. More importantly, this respondent number 31 is mother-in-law of one of the appellants. So he cannot say that he was not aware that respondent number 31 was not alive, or she was made a party as a respondent number 1, despite the fact that she is the mother-in-law of respondent appellant number 4. It's very strange.
No, the objection that she was not substituted does not survive.
Doesn't
Because
survive.
But the decree, her name bears in the
The
decree.
proceeding was ex parte against her.
But
Yes or no?
I can show the record.
If the proceeding was ex parte, the proceeding will not abate.
she was. I'll give the dates also as to
Yes,
when
yes.
she was proceeded ex parte. I have the entire records.
Please defend.
If
Mr.
lordship,
Banerjee, I'm hearing this matter. आपका नहीं देख पाए हैं इसीलिए नहीं सुनेंगे आज. Next आज Thursday है, next Thursday be assured उस दिन हम लोग जरूर से करेंगे. उस दिन लिखाएंगे भी. थोड़ा मुस्लिम लॉ समझने में ना थोड़ा सा टाइम लगता है और this is not very common in our jurisdiction. थोड़ा सा ठीक है.
if lordship could have I have in fact lordship the entire records which has come
Yes.
are in 4 volumes,
Yes.
and I have taken that indulgence, this liberty that I have marked 1, 2, 3, and 4 for the convenience of this honorable court. If lordship could have one,
They must have been substituted in the plaint itself.
yes, they have.
They haven't been yet.
I have one.
I have lordship one. Lordship could have the order dated 15/12/2022.
15, 12, 22.
Both parties are in attendance. It is informed that defendant number 2, Srimati Noor Jahan Khatun, has expired on 6/12/2022. Lordship has seen this order.
Yes.
Lordship may have the order next page, 21st of January 2023. The second part heard.
Just a moment.
Sorry.
Let me just mark on this. Okay, next page.
Lordship has it.
Huh.
Heard prayer is allowed. Second para I am reading.
Yes.
Of 21st January 2023. Heard prayer is allowed. Plaintiff is directed to amend the names of the legal heirs of deceased Noor Jahan Khatun
Yes.
in a plaint and file. I don't know attendance. What is there?
Whatever it is, it was allowed.
Anyway, Lordship may turn to next page the order of 25th of February 2023. The Lordship has that.
25th of?
February. After 17th February, there is a second order. Appears to be 25th February 2023. Next page.
Just,
This second.
yes, 25th February.
Defendant so and so are in attendance. Learned counsel of the plaintiff appears and submits that deceased defendant number 2 was made ex parte by order dated 12th March 2015. So her legal heirs who are substituted defendants are also made ex parte. Heard prayer is allowed put up for 15th
It
March.
makes no difference.
Ultimately,
Even if she would not have been substituted,
absolutely,
it would have made no
Absolutely.
difference.
But
So,
the decree bears her name. Your
Further,
So
lordship,
kya hoga?
the fact is that she is the mother-in-law of the
ultimate
appellant.
decree, if it bears the name, we'll take care of that. We are at the first appellate court, we'll take care of everything. You tell us.
And if lordship
You
could just
argue
see
again
this
of it.
a note I have just prepared of 1 page about this lady and the relation they have. Lordship has this. Respondent number 31, Noor Jahan Khatun.
Yes.
She was defendant number 2 in the suit, but not the principal defendant.
Okay.
She was proceeded ex parte on so and so date.
Yes.
The one line lordship may add that she filed written statement supporting appellate.
She filed with the state.
Written statement. Written statement is on record. I will tell the page number also. Written statement supporting appellate, because she.
No, I don't get it. Then how the proceeding was ex parte?
Lordship, the moment you file a written statement and you don't appear, so you will be
She has
proceeded.
not been.
No.
She never participated. She just filed a written statement,
A separate written statement.
separate written statement supporting the defendant, contesting defendant therein,
Okay.
and left appearing.
When did she file?
She filed way back. Lordship, I'll just in the first volume only. It is given. In the first volume, Lordship could have the written statement by defendant number 2 is at page 62 to 68 of the first volume.
Yes.
I have just taken pain to note down that.
Overwriting.
Defendant number 2, Lordship could see the Noor Jahan
Yes.
from 62 to 68. Page 67 is the verification of Noor Jahan. And she supports the this contesting defendant who are the appellants here.
4/6/2015.
After that, she never appeared, and there is no wakalat nama also. She just, if WS was peeped into the pleadings,
No wakalat.
no wakalat.
Why is there so much of hue and cry with respect to this deceased defendant number?
There is no. The only thing they are trying to say today that when the summons were sent from this court, the report has come that she has expired. So what he's trying to say that as she is expired and she has wrongly been basically arrayed as respondent, so there can't be an argument.
No, I'm not saying
This is what
I'm
So
not.
therefore-
No. Please.
So therefore, if she was already substituted, then her substituted legal years
Absolutely.
must be noticed.
Absolutely.
I'll come to that. Lordship could see my notes further.
Yes.
I'll just say I'm not trying to basically take any advantage of it.
Okay.
If Lordship could see, on 16/1, I have just shown that application under Order 22 Rule 4 was filed. On 21st January, application was allowed. 25th February, LRs of Noor Jahan were also proceeded ex parte. She has 2 sons and 4 daughters. This is very important. And she is the bua also of the appellants, father's sister. Mother-in-law of one of the appellants, there are 4 appellants. Appellant number 4's mother-in-law and bua of all the 4 appellants. The appellant number 4 and his sister got married to children of Noor Jahan. Golat, we will say that brother and sister from this family, brother and sister from this family. So out of 2 sons, Najibullah is the first son, is married to Jahan Ara, who is respondent number 56 and who has been served. So both are husband and wife. The wife has been served by the orders of this honorable court, being respondent number 56. So I don't think that he requires
See,
to.
now the procedure is that the fact remains that in the decree passed by the trial court, Noor Jahan's name is existing.
That is the
That
only.
is the-
That is the only
We'll take
default.
care of that. We'll take care of that. That is the reason that she was made party in this appeal also. Now it has come on record, we have seen the records that she was already substituted. So now, whosoever be their legal heirs, a petition, those persons are to be added because those persons who were substituted.
May I just suggest one thing? Noor Jahan 31 has to be deleted from the areas of party in this memorandum of appeal.
Well enough.
Instead of 31, there will be 6 legal heirs.
All of them are party before us?
Yes. These are not out of these 6, 3 are parties. 2 basically one wife of one this Najibullah is party, and then one of the daughters is wife of appellant number 4. If Lordship could see that out of the 2 sons, one son is the husband of respondent number 56. 56 stands up.
56.
Out of the 4 daughters, Parveen Naz is the wife of appellant number 4.
She herself is not a party here.
She will become a party.
Yes, let her become a party.
No issue on that.
And this chart, have you given it to me?
I'll just. This is only for the convenience of this honorable court. So my submission today is, Lordship, on oral request from either of the parties. I am not putting any blame on him. Could be because of the memo of parties, but the fact of the matter, she happens to be the mother-in-law. They were much aware that she is no more there. But be that as it may, respondent number 31 may be deleted on the oral request. Instead of respondent number 3, the 6 LRs may be brought on record. They may be given thus the service notice to them for them to serve on 6. In the meantime, Lordship could hear the matter on basically broadly taking a bird's view, so that I don't want these technicalities to come in my way, that these respondents were not served or how could the appeal could be heard and decided. I also don't want to get into this technicality.
So, where are your clients stationed?
Jamshedpur.
Jamshedpur.
As per our procedural, they have to move an application.
We have to file an IO.
She will
In
be
fact,
very happy.
in this proceeding, he has to file.
He has to find it.
In this proceeding.
Yes, certainly, they will have to find it. we'll give them a week to do the needful. And so far as those persons who are close relatives of the appellants, you can ask them to appear and file wakalatnama, or else we will issue the notice once you file that petition.
One is the wife,
One is the wife, so you can just, they are
one
all,
is the brother-in-law.
so you can seek instructions, either you ask them that they may appear through you, there is no conflict of interest.
There is no conflict. They are supporting. The mother has supported them.
Yes, either you file wakalatnama or you engage, or they may engage anybody. Why should you engage anybody for that? But that has to be taken care of.
Absolutely.
But
In fact, this to how to have been done. I'm sorry that
it
I
should
could
have
have
been
pointed
done
out.
at your own.
No, Your Ladyship, the executing court is proceeding, Your Ladyship. There is no as such stay. So we are not evading anything. We are
No,
not
no, there
running
is no
away. We are
question
not
of
shying away from
evasion.
the argument. I
There is-
just brought this on record to assist Your Ladyship, nothing else.
आप समझ नहीं रहे, हम दिल्ली के लॉयर को ये बताना चाह रहे थे कि यहाँ पे कितनी तेजी से केस डिसाइड हो सकता है, वो आप बताने नहीं देते हैं.
Absolutely.
Because on the last day when the case was taken up, I told him that we will take up matter the moment the notice
And
is
because of the
complete.
Lordship's endeavour, out of this 58, 57 stands served.
वो पुलिस स्टेशन से हो जाता है सर, हमें पता है
And
ना.
4 का नहीं हुआ था तो हमने वकालतनामा डाल दिया.
दे पुलिस स्टेशन से हम जब भी यहाँ से नोटिस भेजते हैं, जहाँ कंफ्यूजन होता है, जहाँ ऐसा डर होता है कि पता नहीं किसको सर्व करके आ जाएगा, कभी ऐसा हो सकता है, तो हम लोग इस तरह का ऑर्डर्स करते हैं कि थ्रू पुलिस स्टेशन इट इज सर्व. एंड वंस द सर्विस इज कंप्लीट, इसके पहले कि और लोग मरने लग जाएं तो डिसाइड कर देना ज़्यादा अच्छा. अदरवाइज इसको हम छोड़ देंगे तो फिर बाद में कभी अपने यूजुअल टर्न में तो कभी टेकअप होगा भी नहीं.
The impression is being given to my clients, I don't want to take it lightly on that issue, that it will take 5-10 years for this.
नहीं नहीं ऐसा नहीं, यहाँ पे ऐसा बिल्कुल भी नहीं है. यहाँ पे आई टोल्ड यू समय लगेगा, मुझे लगता है समय चीजों को समझने में.
And there is only one ground they have taken in appeal. One ground.
We will see that.
One
So
ground.
how much time do you need to do this?
At least
You
2
should have
weeks.
done it yourself.
2 weeks.
आपको पता है आपके क्लोज रिलेटिव 2 weeks.
Whatever Your Ladyship.
2 weeks is too long a time.
एक घर में है, एक बहनोई है.
हम नेक्स्ट वीक ऐसे ही इसको पोस्ट करेंगे. और ये चार्ट है, आप अपना पिटीशन करें.
ठीक है.
You don't need to.
And the
do that.
application, the details of the addresses of these
Is
legal
also
heirs
mentioned.
are mentioned in the application, which is, if Lordship could see, in the file also at page number 169 of second book. I think I'll just inform that also, so that it will be easier for them to basically locate from the. It is there at page 169, 170 of volume 3. If Lordship could just see. I'm sorry that I've taken that liberty of marking
No,
on
no,
to
no. 169.
170. If Lordship see.
ये दोनों पेज है ना, इसको जो है ना क्लिक करके उनको भेज दीजिए. ठीक है, आपको एड्रेस भी मिल जाएगा.
I have the copy. I can
आपके
give
हाँ आप उनको.
it. मैं दे देता
ठीक है, एड्रेस मिल गया, नाम मिल गया इस चार्ट में. बस इसको हम नेक्स्ट पोस्ट करेंगे.
हूँ. In fact, I have taken these names and all from this application. This is what I was doing in the morning.
अच्छा, ये तो हुआ, इसका वो हो ही जाए. अब आप उनको बताइए मैटर के. Let us just find it
No,
out.
although Mr. Gupta had to
हाँ,
argue
you
this.
just tell us
I will
what is
just-
the
I will just-
matter. मोटा मोटी बात बताइए.
I will just
क्या?
read out the plain and written statement itself, Your Ladyship, because it involves complicated question of Muhammadan law. Your
Not
Ladyship.
at all. Not at all.
Please let me
मोहम्मदन
speak.
लॉ बोलने से complicated by
My senior is not letting me speak. Your
नहीं, but I'm saying it's not, no complication. One issue, Hiba.
हिबा में भी क्या इशू है?
Hiba में issue ये है, they say that my grandfather executed an oral Hiba in favor of my father in 1967. Date not mentioned, place not mentioned, witnesses not mentioned in the written statement. Their father died after filing the written statement. All the 4 appellants who came in the shoes of the father filed again a written statement, which is another that they could not have filed a separate written statement, but they have filed the same written statement. They said that in 1967, when they were 14, 16 and 19 years of age, grandfather executed an oral hiba in favor of my father in the presence of witness, names not disclosed, date not disclosed, place not disclosed. In the examination in chief,
No, I fail to understand one thing.
yes,
As per them, there is a oral hiba in favor of your father.
My father.
Your father.
My father.
their
Your
grandfather is common.
A.K. Ghani is the common ancestral.
Abdul Ghani was the grandfather who had 1.5 बीघा of land in his favor.
वो उनके father के favor में बैठे. So
इनके father के
they are claiming the entire
जो
property.
original defendant number 1 थे,
Coupled with possession.
हाँ,
They
coupled
said,
with
because they
possession.
were staying.
Even the records of right was in the name of Ali Alam Validation. Even there was rent receipt which were issued in his name.
I'll just
Corrections
let me explain. I'm just giving a bird's view. It is not that I'm trying to basically
Yes,
prejudice
yes.
your case.
Let us just
Giving a bird's view on that. So the sons also took the same view. 4 witnesses they examined. I filed a partition suit. I said that I'm also the descendants of Abdul
Certainly.
Ghani. I filed a partition that it has not been divided. So they were staying. The moment I came to know that they are collaborating with the builders, I filed a suit immediately. I asked for my share. They said that no share. We filed a suit. They came out in the written that there is a hiba. 4 witnesses they have examined. 2 witnesses are the 2 appellants who were minor at the time in 1967. 2 witnesses more they have examined. One was their Samdhi who said that I am in Dhanbad. I used to come to Jamshedpur, but I came to Jamshedpur only after 75. 67 he was not. Another witness was brought who says that I was also one of the witnesses to the hiba, because in the examination in chief, these witnesses brought the names of 3 persons as witnesses. None of the 3 were examined in the court.
In the original written statement, the name of witnesses were not mentioned.
Not given. Neither by the father nor by this present appellant. In the examination in chief, for the first time, they brought in 3 names. They did not say that whether these 3 persons are alive or dead. None of the 3 persons were examined before the court. One person, defendant number 4, said that I am also one of the witnesses and my father out of the 3 was also witnesses. He also doesn't say that my father has expired. And in his examination in chief affidavit, he writes that I am so and so Farhan Ali, son of so and so Ali. He doesn't say that late. All others say son of late so and so. He says that though I was 14 years of age at the time, but I was also witness. So this is the crux of the hiba. The law is very clear that in Muslim law, hiba is allowed, oral hiba is allowed, it requires no registration. But at the same time, Mullah says, coupled with the judgments of the different high courts and Supreme Court, that this is the right which is given to the Mohammedans, but it has to be taken all care and caution to accept that whether the hiba was actually done or not. Because the onus is on them to establish 3 aspects. That the hiba was, the donor executed the hiba, means he bequeathed those property by way of oral hiba. The donee accepted it and the possession was given. While the donor giving it to the donee, the declaration to the world at large has to be made that I am declaring that this property which is owned by me in the presence of so and so person, I bequeath this property irrevocably in the name of one of my sons and I am giving possession there too. Even if place not known, date not known, witnesses not known, witnesses not examined. Keep this aside, the biggest problem which came from them, that they say that no, my grandfather in 1967 bequeathed this by oral hiba, he died in 1981 after around 14 years. In 1972, their father became the ward commissioner in a particular area in Jamshedpur. By way of survey settlement, the father of the appellant got his name in the survey settlement. On the basis of survey
In
settlement,
72.
72 and the name reflected in 79.
And possession since?
Possession, because he was the only son, he was staying in
Was
Jamshedpur.
it mentioned? Possession since?
Yes, possession we are not disputing. We did not dispute the possession because he was allowed to stay in that house and to do.
He was in possession even prior to.
Yes, much prior to, he was there in the possession, he was in possession. No issue on that. The problem was that because it came out from their own documents, that mutation was also done on the basis. In the mutation records, there is a column that what is the basis of mutation, whether it is sale, gift, conveyance, succession. He writes not gift. Had it been, and this mutation was done in 87, had it been Hiba, the column would have been gift. The column says Khatiyan ke parche ke basis. So that went against him because the contemporaneous evidence has to be there. Had this been a Hiba in 1967, in 1987 when they got mutated, the basis of mutation ought to have been gift when the columns are mentioned as to what is the basis of mutation. The second aspect is that much after the year of Hiba in 1967, in 1973 and 75, the grandfather fought the case of C&T. He would not have. Had he bequeathed this property to his son, he would not have. Why should he be bothered to fight the cases when he is not the owner no more? He will say, ask his son to do those. This is also on record. These two documents were the clinching documents. The documents, the documentary evidence which totally went against them, apart from the witnesses who were not examined. So this is the crux of the case for Hiba, and it is a law that the law is that if Hiba is to be accepted, and if there is any doubt that the benefit will go to the persons who are otherwise inherit the property. The benefit will always, the mullah says, the judgment says. So I have annexed the relevant portion.
So you need to respond to this, that you tell your senior he will have to respond to this, that okay, oral gift is permissible, but can there be a gift without any foundational details? Where, what date,
That date is not mentioned.
in whose
I don't-
presence? You do not say that who are the witnesses to the Hiba, and then at the time of evidence you produce whomsoever you want to.
And even he was not examined.
Is it permissible under law?
We'll look into that.
And if Lordship could for a moment,
Hiba, okay, oral means what? It is not in writing, but rest of the ingredients has to be there. Date, time, place, nothing is mentioned.
and Lordship for a moment, if Lordship,
As he says, I don't know.
yes, I'll just, if Lordship could just see in part 2, page 183, for a moment, Lordship, things will be very clear.
इसको दीजिए जरा.
Part 2, page 183. Lordship has that. This is
Yes.
Exhibit H,
83, exhibit H.
183. Lordship, this is the order of 30th of November 87 on the left side.
हाँ.
This is the mutation order in the favor of their father. If Lordship would just turn to page 185, 185. If Lordship has that?
Yes.
This is appended to the mutation order. If Lordship put this is appendix C, and if Lordship could see, the entire details are mentioned. 1, 2, 3, 4, 5, 6th column. Whether the mutation is due to sale, gift, exchange, succession, or partition. Lordship, see the column.
खतियानी
The answer is Khatiyan Parcha ke aadhar pe. So you create your names in the survey settlement, and on the basis of survey settlement you get it mutated, and then you say that I have paid, I am paying everything, I am doing everything. So therefore this basically runs on, this is in teeth of the concept of
So
Hiba,
this mutation would at least not show that
and this is of
that
87.
oral gift of Hiba was accompanied with delivery of possession. Normally, if there is a mutation immediately after Hiba, people would say yes, there is a mutation. Now that oral gift was followed by delivery of possession, and therefore there was a mutation. But this mutation much later.
After 20 years.
Later, after 20 years and after the death of grandfather.
Yes, he died in 81.
Therefore, it will not show that mutation was pursuant to Hiba.
And they would have written it.
But they
Otherwise
did not
also-
make any objection, your edition.
That was the main argument, is recorded in the trial. I argued the
You
matter.
see, we are not prejudging it. We are just indicating that these are the issues that will crop up.
And then one more.
If this is a fact that mutation was done only much later, then under such circumstances, the basis of your mutation is not Hiba, rather basis of your mutation is some entry made in the record of rights wherein you were found in possession. And they say that you were bound to be in possession because they were not there on the spot. Merely because you were in possession does not mean that you were in exclusive possession.
Or having ownership. And Lordship, there is one more page, and I'll just rate my
नहीं
one.
वो बहुत जूनियर है आप उसको
I'm
nervous हो गए हैं।
I'm just basically trying to Lordship, see in the same volume, page 120. Same volume.
120.
120 and 122. These were the two clinching documents. This is the Lordship. Before looking into 120, look into 122 first, because that appeal order is before the original order. 122 is the order of 1973. After 5 years of alleged Hiba, it is between the state and Abdul Ghani. He fought the case. He fought the appeal also. These are the two pages. In 1973. And they admit in their evidence, yes, it was my grandfather who was fighting the case. Why the grandfather who has bequeathed the property to one of his sons will keep on fighting cases under C&T after 5 years of alleged Hiba, which is very abnormal. It cannot be. He'll say that I have already, this property has gone to one of the sons, he has to take care of this.
So let us hear him for 2 minutes. आपका कुछ खास केस है? Have you read it?
No, Your Ladyship, I am checking only one Indian.
I will give you indictments. अभी आज तो नहीं
I am not prepared with the
If you want to say anything, you can say yes, say so much. Yes.
No, one Indian.
So I am posting it next week. You'll file your interview application. The learned counsel for the parties are present. It has been reported that respondent number 31 has expired. The learned counsel for
During the pendency of the suit itself.
During the pendency of the suit, the learned counsel for the respondent has submitted that the respondent number 31 in the present case was defendant number 2, and she expired during the pendency of the case after filing the written statement by her. The suit proceeded ex parte, wide order dated against her, wide order dated 12/3/2015. She expired on 6/12/2022, and her name was also substituted in the records. But in the final decree, her name is appearing.
Names of the legal heirs are not appearing.
Her name is also- her name is
Appearing and the legal heirs
But
are
the
not
name
appearing,
of the legal heirs and successors are not appearing.
despite the fact that they were taken on record.
In spite of the fact that
The
she
application.
was substituted. He submits that consequently respondent number 31 has been made party. The learned counsel has also submitted that respondent number 31 is a close relative of the appellants.
Mother-in-law, one of the appellants.
Is close relative of the appellants, and they knew quite well that she had expired and was already substituted. Counsel for the appellant prays for time to file appropriate petition in this case. Decree तो हम लोग यहीं से भी modify कर सकते हैं.
That the appellate court has power. all the
Appellate
powers.
court has the power. We will do that.
And that is only a technical defect. It is not even touching any merits of the case. So Lordship is putting it.
Next Thursday. Next Thursday.
The first of May. That's a good Labor Day.
First of.
Lordship putting it any time.
It will be just a formal order.
So I need not come.
You need not come, or you can join online also.
That will be okay. So only request I make Lordship that if the matter would, because this is the only argument.
You see, once the service is complete and parties appear,
Lordship,
and the
because
board continues,
what I'm saying,
surely
what I'm
will.
requesting that if Lordship is putting it to next week for him to move an application, then thereafter the service will start.
certainly.
But what I'm saying that he is not a new respondent, and his legal heirs are not the respondents whose mother has expired during the pendency of the appeal. But he has to.
He has to file an application.
I know, but Lordship, by that time he should have basically the notice. If Lordship could say,
You see, if they want to appear on their behalf also, they can file. Wakalatnama.
Lordship may record that, but otherwise it will basically on next Thursday. It will be the purpose of application. Then there will be no issuing of notice. This is the only.
आप बताइए, आपका यहाँ पर अपील जो है 19/12/24 को फाइल हुआ, उसके बाद ये डिफेक्ट कुछ दिन रहा, नहीं 19/24 को फाइल हुआ, उसके बाद कुछ दिन डिफेक्ट रहा, एक साल तक तो डिफेक्ट में पड़ा, नहीं 19/12 एक साल
In December it was.
15/1 को आपने डिफेक्ट ये मैटर बोल पड़ा.
I'm not the culprit.
No. Just 15-20
Lordship
days
is saying
we removed
towards
it.
me, I'm not the culprit. And rather I was the caveator.
कोई बात नहीं. आप आ जाइए नेक्स्ट थर्सडे. We'll do it, don't worry.
The
आप
only
अपने नोट्स बढ़िया से बना लीजिए, तो आपको जर्नल भी साथ साथ देंगे.
if the only request, Lordship, if Lordship could accommodate a week thereafter for hearing the matter, if possible. But I think by 7th or 8th, if Lordship could hear, the only request,
नोटिस सर्विस के लिए थोड़ा टाइम देना पड़ेगा.
half of they are the family. One is the brother-in-law, another is the sister.
There is no stay on the execution proceeding.
Does
No, no,
make out a case for a stay.
We'll do that.
और ये कहाँ स्टे?
There is no stay. Therefore, I'm
स्टे
saying
नहीं
that.
होता है यहाँ. इस तरह से.
But
देखिए बहुत ज़्यादा फास्ट ट्रैक भी नहीं कर सकते.
I can understand. That's why I say that these formalities has to be done, because otherwise it will boomerang on me only.
अगर उस दिन आप बोलते तो हम लोग.
It was my fault because I was not even served with the appeal. I was served with the appeal 2 days back. Despite the fact that there was an order to the effect, I wrote to them that you have not complied with, you have not given me the copy. Yes, Saturday I was given. So I never wanted to say anything on that account. That's why I started.
अगर होता तो हो
I would
सकता है
have
कि
pointed
आज
out on that day
mature हो
itself.
जाता case.
The day would have been saved. Anyway, Lordship, so always next time.
Rest of them have been served.
Rest of them, Lordship may record that. The service, because Lordship may say,
दिखाई जरा
yes,
service.
yes, Lordship may say that. And
We have filed a supplementary affidavit.
but that supplementary affidavit is not
दस्ती.
Lordship, but that supplementary affidavit is not correct. I will point out. I have seen that supplementary affidavit. Lordship may record that. If Lordship could see the last order, Lordship had recorded that who has filed the wakalatnama and who all needs to be served. While recording that, Lordship, who were all left were 32 to 37 we have filed wakalatnama again. Means for 32 to 37 we have filed wakalatnama.
Okay.
That is one part.
Is there anybody to be served?
No, Lordship. And 38 to 41 and 55 to 58 have been served.
As per office note,
Yes. The
respondent
office.
number 38 to 41
Yes.
and 55 to
Lordship, it is.
58.
It is थोड़ा सा उसमें गलती है 57 के बारे में मेंशन नहीं है लेकिन सर्विस नोटिस मैंने देखा है शी हैज रिसीव्ड if lordship could see her 57
The 55 to 58 have been served either personally or through their close relative.
yes
Accordingly, the service of notice upon them is accepted as valid. Bas respondent
except
number-
31 there is no one who needs to be served.
Counsel for the parties have submitted that except respondent number 31.
Legal heirs of respondent 31.
Respondent number 31 who has been reported dead as per office note. Rest of the respondents have been served. Correct?
In fact, Lordship, in some of the matters in Delhi, in such cases when there is no interest prejudicial to the appellate, the court even dispenses with the service. But I don't want to get into that.
Because that unnecessarily, you see, the proceeding was also ex parte against them, but still,
Their stand is supporting me. If they sail through the appeal,
that's
they are happy.
no, we can't dispense with the service.
Anyway.
Dispense that.
Much obliged.
Obliged.
Is to pronounce it.
For judgment item 1, second appeal 390 of 2017.
Having decided all the four substantial questions of law in favor of the appellants, the judgment dated 12/7/2017 passed by learned Principal District Judge Garhwa in Civil Appeal number 9 of 2016 is set aside, and accordingly this appeal is allowed.
Item 15, second appeal 610 of 2017.
Mr. Sani, your case has been called. बताइए क्या करना है इसमें?
In this case, the plaintiff is the appellant in the court below. Here also appellant against the part of the decree passed by the appellant. The suit was filed for declaration of right title interest of the plaintiff over the suit land A and B, Schedule A and B. Suit for declaration that the plaintiff is owner of Schedule A and B land having purchased from the recorded rayat in possession and for confirmation of possession. Second fair note record of right dated 10th of August 1979 did not affect his time. If Lordship may kindly see, the learned trial court have decided there are 7 issues, out of which the learned trial court decided all the issues 6 and 7, including 6 and 7, against the plaintiff. Now on appeal, if the Lordship may kindly see on appeal, page 12, para 12, page 8 and 9 of the appellate court judgment.
Yes.
8 and 9. Lordship will find
Yes.
the issues are in para 4. Issue
Appellate
number
court
6
judgment.
and 7, para 6 starts now. Findings, lower court findings. Then were the arguments, thereafter findings in para 9. Para 9 at page 6.
Yes.
Are the parties para 10. It is important to mention that the plaintiff has a very definite case of having purchased the property from his vendor by virtue of registered sale deeds, and that his vendor was in possession of the property who, in their turn, had purchased the property from the lawful owner. If the claim of the title is locked into then, in respect of Schedule A property, there is no document of title prior to 1955. While regarding Schedule B property, there is no ancient title prior to 1967. Both these properties, the source of title as stressed by the plaintiff appellant is through Exhibit 2 and 2IA, which is certified copy of Khatian which shows that the lands in question has been recorded in the name of Bihar Sarkar as Anabar, and the lands has also been lands also have house over it and is recorded to be in illegal possession of the predecessor in interest of the plaintiff. The main point for determination in this case whether the plaintiff has acquired any right, title and interest over the property or not, whether the suit brought by the plaintiff of declaration of right, title and interest over the suit property is maintainable or not.
You were seeking adverse possession.
No, no. You know, just see paragraph 11.
What was your basis for right?
No, para 11, you will see my kindly see the answer. Para 12. The findings recorded by the learned appellate court, I am reading your para 12. Issue number 7, which was also decided against the plaintiff and prayer made by the plaintiff that they are not bound by the entry in the record of right in the year 1979 was not accepted by the court below. The court below has not committed any error of law, fact in passing said order. Firstly, the entry which was finally published in the year 1979 could not be challenged in the year 2012, nor any objection was filed in terms of Section 83. Then, as already held, the plaintiff held that the plaintiff does not have any right, title and interest over the suit claim in dispute, but the second part of issue number 7, which relates to permanent injunction restraining the defendant from interfering from the right, title, interest and possession of the plaintiff over the suit property. The finding of the court below on this part of issue number 7 requires to be interfered with. No injunction can be granted from interfering with the title of the plaintiff because the plaintiff does not have any title over the suit property and the plaintiff do not confer any title of the plaintiff. But in view of the fact that the plaintiffs are in possession of the suit property and the relief of permanent injunction restraining the defendant of the respondent from interfering with the possession of the plaintiff opponent except in accordance with the procedure prescribed under the law is granted. The defendant respondent is at liberty to take a step for recovery of possession in accordance with procedure established under the law but shall not forcibly or illegally interfere with the possession of the plaintiff over the suit property. It is reiterated that the factum of possession of the plaintiff or their predecessor in interest has been acknowledged by the state as despite the fact that the land is stood recorded as Anabar Bihar Sarkar, but in column number 4 it is mentioned to have house over it. Hence the land is not a Anabar land, rather it is a house land and bari land as it appears from the remarks column as column number 4. Besides, illegal possession of the predecessor in interest of the plaintiff is also admitted and acknowledged since 1955 and 1967, respectively in respect of Schedule A and B. Hence, findings on issue number 6 and 7 are partly modified and to that extent is set aside. So, it is a reversal not with regard to issue number 6 and 7. Now, the finding of the court below on issue number 4, which relates to the question of limitation, also appears to be only partially correct. It is true that the plaintiff cannot challenge the entry made in the survey record after more than 12 years from its final publication reliance in this regard placed in such and such. But cause of action is not a single fact, rather it is a bundle of facts. The plaintiff
So your title was not declared, injunction was granted,
injunction and possession.
possession was
Possession.
declared.
My relief was with regard to the not interference with the possession of the plaintiff.
So you got the relief?
But that part has been wrongly decided.
No, you just see the operative portion and read it.
The decree, there are two reliefs. One, the learned appellate court agreed that the lordship can see if the 1955 possession, the vendor, there are 3 vendors. One after another, I purchased the sale this note from the 3rd vendor. The first vendor from the 1955 possessee who transferred to A transferred to B transferred to C, and house was constructed by A. That has been found that the house is there. The learned appellate court also recorded the finding. It is not Anabar. There is a house existing since 1955. Secondly, the learned appellate court also found the house existing since 67. There are 2 parts. Schedule A, 55.
No, I don't get it. What was your relief? You just wanted your possession to be retained. Your possession has been declared. You have been given injunction.
Yes,
What else do you want?
Now, if the possession follows the title, my humble submission, the learned appellate court erroneously did not decline to grant relief note with regard to title if the possession is signed since 1955.
So it was your title suit also.
Yes, it is a title suit. So, my possession followed the title. Now, if the learned appellate court found and it has been accepted that it was acknowledged by the respondents, my possession, that has been finding.
What is the ground on which your title has been declined?
Yes,
So you see,
that is my
ultimately your
no
possession
discussion.
has been found.
No
The injunction has also
yes,
been
but
granted.
still no finding has been recorded as such.
That's a
It is not-
question.
Only the concluded
Where is the
part.
point of
Yes,
determination?
now I am just.
Where
that
is
the
the
reason
point
I
of
was
determination?
reading para 14 only. Your Lordship may kindly see coming.
Just a
on
moment. Let us see the trial court. Trial court must
Yes.
have.
Trial court finding.
Where is the
Yes. Yes.
where is the issue regarding title?
Yes. Issue number 4, 3 and 4. Your Lordship just see the issues are at page. In the trial court
Yes,
judgment,
issue number 6.
6 and 7 decided in my favor. So issue number 6 and 7 have been decided by the appellate court. So that is my submission for Lordship. If your Lordship may kindly see the whether issue number 5 and 6 and 7, these are the main issues in the trial court. Trial court decided the issues against me. Now appellate court, while deciding in my favor, acknowledging that the defendants have acknowledged my.
It is held that the plaintiff does not have any right title over the suit property, but the possession of the plaintiff over is confirmed.
Therefore,
This is the finding of the learned appellate court.
that is my submission.
So
If
there are concurrent findings that you do not have title over the
there
property.
must be some discussion.
Yes,
There is
must be
issue
some
number 6.
discussion.
That is the reason I read.
So you are not reading it.
I have pleaded it.
No, you are not. You are not reading it.
Para
You
12,
just read
Milord.
para 11. 11
Para
to the
11,
point.
issue number 6 and 7. Now, Milord, I have read Milord para 12.
Why
I'm
you
reading
read
para
want to
11
read
also.
only para?
Para
Yes.
11.
You read.
Yes. Issue number 6 and 7, which were taken by the court below, for adjudication on the priority basis, confers around the question which has been framed by this court. As discussed above, it is not in dispute that the record of right as per the last survey settlement shows the entry in respect of the land to be in the name of Bihar government as Anabad. That was negated. Anabad, the learned appellate court negated it. The possession of the predecessor in interest of the plaintiff is also shown to be illegal possession. Expressly, the defendant has not come with a case of adverse possession. Defendant, I am the plaintiff. But if the relief as prayed for by the plaintiff appellant in its plate is considered, it would be apparent that the appellant had made a prayer also on the point of adverse possession. The law is settled. The adverse possession cannot be used as a sword, and the suit on the basis of adverse possession will not lie. A person can defend his possession on his claim of adverse possession. This has been settled by the Honorable Apex Court in the recent judgment of 2014-1 SCC 669. However, the plaintiff appellant in course of argument submits that he has a case of title and not of adverse possession. If that be so, then the plaintiff will have to complete the chain. The claim of title in the documents being Exhibit 1 series did not complete the chain of title, and ancient title which relates to Exhibit 2, the predecessor in interest of the plaintiff, shows that he did not have title over the property. In the law is settled that no rigid person can transfer any better title than what he has had. A person in illegal possession cannot transfer better title to dispute purchase. I would also like to refer to the deposition of the witnesses examined on behalf of the plaintiff, particularly.
You see, the possession was written as illegal possession.
That is written not in 1955.
That's it. What you see, your vendor. What was the title of your vendor? What was the source of title of your
Possession
vendor?
was recorded in the record of right
Yes.
in the remarks column as
Yes.
illegal possession.
Illegal
That
possession.
is there.
Yes.
Now, Milord, it has been held by this appellate court that there is a house constructed by my predecessor.
So
But if the
that
son-
will not become legal possession.
if the house in existing since 1955 and 1967 as recorded by the learned appellate court,
Yes.
and that was not denied by the defendant, and they have acknowledged my possession, my predecessor's possession, continued since 1955, and in the year 2012, it is more than blood.
You are not claiming adverse possession. You have refused to claim adverse
No,
possession.
that is in the LLC
आप
में
तो
क्या
लिखे ही हैं यहाँ पर, आप ही का ऑर्डर लिखा हुआ।
उनका ऑर्डर में गलत,
ऑर्डर में गलत है, कहाँ लिखा है? ऐसे
खुद
थोड़ी
लिख
होगा
रहा
ऑर्डर में गलत।
ऊपर में क्या लिखा है? ऊपर में
You see,
लिखना
the
है
law is settled that adverse possession cannot be sought.
That
ये
is
उसके
also
बाद,
wrong.
however, the plaintiff appellant in course of argument
that
submitted
is
that
also wrong. But LLC में
that he has a case of title and not of adverse possession.
prior to that, just 2 lines prior to that, above that, the possession of the such and such, in its plaint, it is expressly the defendant does not come with such and such. The relief as paid by the plaintiff in its plaint is
Limitation
considered.
activity.
It would be apparent that the appellant made a prayer also on the point of adverse possession.
What was the date on which your possession became adverse?
1955, as per my predecessor, which has been recorded by the appellate court. Appellate court already found it, and that is the ultimate finding, that the land is not an Abad land, rather it is a house.
देखिए, second appeal number 610 of 2017. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the suit was filed for declaration of right, title, interest and possession. He submits that the learned appellate court has declared possession in favor of the plaintiff, but so far as title is concerned, the same was declined. He has also submitted that the learned appellate court, by considering issue numbers 6 and 7, has recorded that the perusal of the plaint revealed that the plaintiff had claimed adverse possession over the property, but the appellate court recorded that the law is settled that adverse possession cannot be used as a sword, and the suit on the basis of adverse possession will not lie. The learned counsel submits that such observation of the learned appellate court is contrary to the judgment passed by the Honorable Supreme Court reported in कौन सा judgment बताइए? Adverse possession, which can be used as a
Latest है
ठीक है, हम डाल देंगे इसमें. He has submitted that the appellate court has wrongly recorded that the counsel for the appellant in course of argument had submitted that he had a case of title and not that of adverse possession. He has submitted that there are foundational pleadings and materials on record to declare adverse possession of the plaintiff over the suit property, and therefore the learned courts have not considered the case of the plaintiff with regard to adverse possession. Learned appellate court, trial court क्या किया था?
Trial court सब reject किया था. Issue number 6 and 7 decided against me.
Accordingly, this, considering the submissions, this appeal is admitted for final hearing on following substantial question of law.
Roman 2 at page 5. Roman 1 and 2 are mostly देखिए.
Six होने से नहीं हो जाएगा?
हाँ.
6 नहीं, एक
Substantial question में Roman 2 है लेकिन 65 नहीं है. Article 65.
3 में है.
जी. 3.
whether the learned appellate court, having declared continuous possession of the plaintiff through his predecessor in interest, whether the plaintiff was entitled to a declaration, entitled to declaration of title through adverse possession. Whether the learned first appellate court failed to consider the claim of the appellant with regard to adverse possession in the light of the judgment passed by the Honorable Supreme Court reported in such and such, read with Article 65 of the Immigration Act. नोटिस करिए ऑर्डिनरी प्रोसेस कहाँ है रेस्पोंडेंट लोग? Where are the respondents?
Where the respondents are not phone number.
Respondent is state.
Only one. State.
Let notice be issued to the deputy commissioner. Notice be issued to respondent number to the sole respondent, for which requisite under ordinary process be filed.
2019 by 127.
2019.
19 volume 8
Volume 8 SCC
729.
729.
Ravindra Kumar Gerewal.
हाँ, वो लिख दीजिए, दे दीजिए.
Here I was aware, but there is a 23 judgment also. I think.
हाँ, तो बहुत सारा हम भी एक आदमी की. हाँ, देखो कॉल पर करिए, एडमिट हो गया. अब तो एक नोटिस आप कर ही दीजिए. Ordinary process का within 1 week. Post on 9th of July.
9th July.
9 जुलाई. लंबा हो गया क्या? तो कोई बात नहीं, आने दीजिए, इतना क्या ही डिसाइड कर पाएंगे. कम से कम सर्विस कंप्लीट हो जाता है तो फिर.
Orders item 7, second appeal 170 of 2016.
Yes. What is it?
Your Lordship, one IA number 4881 of 2025 has been filed for amendment in IA for substitution, Your Lordship. Earlier in 2000.
Why for amendment? Where is the substitution petition?
IA number 9395 of 24, Your Lordship.
9395 or 24.
Yes, Your Lordship.
Okay. Now why substitution?
IA number 9395 was filed for substitution of respondent number 5, Your Lordship, namely Bipin Bihari Azad.
Yes.
But a counter affidavit was filed by the respondent stating that the names which we have stated in the heirs and legal representative, that were not correct. So in light
So
of
you
that,
have filed a fresh petition or you have filed an amendment?
amendment petition, Your Lordship.
So objection? देखिए IA number 4881 of 2025. The learned counsel for the appellant has submitted that the petition has been filed for amendment of the substitution filed in connection with deceased respondent number 5 through IA number 9395 of 24. He has submitted that the respondents had indicated in their counter affidavit certain errors which has been made in IA number 9395 of 2024, and accordingly the petition for amendment has been filed. considering the aforesaid submissions, the learned counsel for the respondent has no objection with respect to IA number 4881 of 2025. Considering the submissions, IA number 4881 of 2025 is hereby allowed. The learned counsel for the appellant is directed to carry out necessary corrections in IA number 9395 of 2024 with respect to the legal name of legal heirs and successors of deceased respondent number 5, whose detail has been mentioned in paragraph 4 of the IA number 4881 of 2025. यही है ना?
Yes, Your Lordship.
चलिए ये हो गया अलाउ. अब in writing during the course of the day कर लेंगे. अब बताइए, अब इनको नोटिस कर लेते हैं. आइए में आप सबकी तरफ से अपील हो रहे हैं कि नाम बताइए, अपना नाम बताइए. हाँ दीजिए जरा नाम का इनका. ये 1 2 3 4 5 6 लोग हैं, 6 लोग हैं. मिस्टर सो एंड सो एडवोकेट. नहीं, उसके बाद देखिए आई नंबर 9395 of 2024. Counsel for the appellant has submitted that this petition has been filed for substitution of deceased legal heirs and successors of this for substitution of deceased respondent number 5. When did he die? Mr. So and so,
Yes, Lordship.
who died on 37/2024.
Yes, Lordship.
Mr. So and so accepts notice
Your Lordship,
on behalf of the legal heirs and successors of respondent number 5.
Your Lordship, in the affidavit filed by the respondents, in para number 6, it is written that the wakalatnama has been executed with this affidavit on behalf of heirs of respondent number 5.
ठीक है तो कर. You have filed वकालतनामा already?
नहीं.
तो बोल रहे हैं कि already filed. गलत बोल रहे हैं. इसमें तो है लगता है. आपने तो फाइल किया हुआ है. किसका नाम है ये? मुकेश. ये तो आपने फाइल किया हुआ है इसमें, है ना? He has submitted that wakalatnama on behalf of the legal heirs and successors of respondent number 5 has already been filed along with supplementary affidavit dated 25/2/2025, wherein the details of the legal heirs of respondent number 5 has been mentioned. या ये अलाउ कर दीजिए 9395 of 20. आपको कोई ऑब्जेक्शन है? तो ये दोनों आइए. अब क्या बचा है इसमें? What else? सर्विस तो कंप्लीट है ना सर?
Yes, yes, Lordship.
क्या लिखे? नोटिस इन व्यू ऑफ ऑर्डर डेटेड 6/4/23. इसका क्या मतलब है? ये जो लिखे हैं इन व्यू ऑफ ऑर्डर डेटेड 6/4/23, इसका क्या मतलब है? अच्छा, तो सब लोग हैप्पी हो गए मेरे ख्याल से.
सभी हुए हैं, लेकिन उसमें जो रिस्पोंडेंट नंबर 9 है तो वकालतनामा में फाइल किए तो
अच्छा, रिस्पोंडेंट नंबर 9 की तरफ से कौन है?
5 and 6.
9
8 to
9
13.
9 8
8
to
to
13
13.
आपका 9 का वकालतनामा मैचिंग नहीं, रिस्पोंडेंट नंबर 9 का वकालतनामा। ऑफिस नोट में दिया है क्या?
ये ऑफिस नोट में लिखा हुआ है।
रिस्पोंडेंट नंबर 9 का ऑफिस नोट में दिया है क्या?
यस यस।
It has been pointed out by the office that the name of respondent number 9 is Abha Devi, daughter of Sitaram Paswan, wife of Awadh Bihari Paswan. As mentioned in the Wakalatnama, does not tally with the details of respondent number 9, which is mentioned as Hawa Devi, H-A-W-A Devi, D-E-V-I, daughter of late Sitaram Paswan, wife of not known in the memo of appeal. ये नाम थोड़ा सा आप चेंज करिए। आभा देवी की जगह हवा देवी।
हवा देवी का
नीचे टाइटल सूट अपील से यही नाम चल
यही नाम
डिग्री
होते हुए
हवा देवी चल रहा है।
हवा देवी। और आधार कार्ड में आभा देवी।
तो भाई इसका आपको कुछ एफिडेविट फाइल करना पड़ेगा, ऐसे कैसे होगा? आप कुछ एफिडेविट फाइल करिए। और नीचे कोर्ट में आपने वो क्या फाइल किया था, वकालतनामा? आभा देवी की हवा देवी?
हवा देवी।
हवा देवी। जब हवा देवी अब इसका क्या करें बताइए? ये सेकेंड अपील में है आपका मैटर, ये हम लोग कैसे चेंज करेंगे? वहां पे जब आप
सिविल में तो एलियस भी है।
एलियस नहीं, हम आई डोंट नो हम एलियस नाम यहाँ पे कैसे देंगे? कुछ उपाय लगाइए, सीनियर लोग से पूछिए। जब वहाँ पे आपने जो वकालतनामा फाइल किया है वही वकालतनामा यहाँ पे फाइल करिए। उसके बाद यू सी के डिक्लेरेशन दैट यू आर वन एंड द सेम पर्सन। Also further respond number 9, prays for time to seek instruction and take appropriate steps in the matter. ठीक है? कुछ एक एफिडेविट फाइल करके देखेंगे हम लोग। ये एडमिटेड है?
Yes, Lordship. Yes, 29-22 के ऑर्डर से एडमिट।
इसका तो हम कुछ नहीं कर सकते। पोस्ट ऑन 29 जुलाई। इसमें कुछ क्या उपाय है इसका बताइए?
लोअर कोर्ट में अमेंडमेंट डाल सकते हैं 152 में, अमेंडमेंट इन जजमेंट एंड डिग्री।
तो भाई आप तो कुछ स्टेप ले लीजिए अपने खुद से। आप प्लेंटिफ है डिफेंडेंट है?
डिपेंडेंट से
आप डिफेंडेंट हैं, तो आप लोग कर लीजिए कुछ, नहीं तो ये तो कहानी खत्म ही नहीं होगा। एफिडेविट यहाँ पे नहीं होगा, ये सब कहानी यहाँ पे नहीं होगा। आई विल नॉट परमिट ऑन दिस। आपको लोअर कोर्ट में जाके अपना जो भी नाम वाम जो भी चेंज कराना है, यू हैव टू से दैट यू हैव बीन अपीयरिंग, क्योंकि नाम ऐसा था इसलिए आपने ऐसे लिख दिया। अपना आधार वाधार लगा के आप अपना आइडेंटिटी ठीक से डिस्क्लोज करें। उसके बंदी को शायद को पता होगा, आप उन्हीं के साथ है ना, तो थोड़ा समझ लीजिए, सीनियर से समझा कर लीजिए कैसे क्या होगा। नाम का डिस्प्यूट रह जाएगा तो प्रॉपर्टी आपका होने के बाद भी नहीं होगा, ठीक है? हार जाइएगा तब तो कोई बात नहीं।
Item 8, second to 375 out of 116.
हाँ बोलिए।
In this matter, there was a direction to file substitution petition.
हम लोग डायरेक्शन नहीं देते, इट इज योर प्रेरोगेटिव। इफ यू डोंट फाइल इट दैट इज योर प्रॉब्लम।
लेट्स सपोज में हुआ कि सब्सिक्वेंटली क्लाइंट आए थे, उनका कहना है कि petitioner number 8 has not died leadership because 3 other petitioners who have died. So we have
Who
asked
have died?
petitioner number
Appellant.
appellant number 2, 3 and 13.
2, 3, 13
Yes,
have expired.
They have it.
And 8 is alive.
8 is alive. So we have asked him to come up with all the relevant documents, the death certificate, and pursuant to that.
ये जो आपका ऑर्डर है इसको मॉडिफाई कराना होगा ऑर्डर, आप पिटीशन फाइल करें, ऐसे नहीं परमिट करेंगे, साथ में सब्स्टिट्यूशन भी फाइल कर दीजिए, ठीक है। Essay number 375 of 2016, Council for the appellant has submitted that appellant number 2, 3 and 13 have expired, and he has been instructed that appellant number 1 is alive, appellant number 8 is alive. However, in order dated 6th of January 2025, it has been recorded on the submission of the Council for the appellant that appellant number 8 had expired. Council for the appellant prays for some time to file appropriate petition for modification of order dated 6th of January 2025, and also for taking steps in connection with deceased respondent number 2, 3 and 13 as per law. बताइए कब रखें? कौन सा दिन?
Second,
18th.
Item 9, second appeal 191 of 2017.
ठीक है।
Notice for the suit to respondent number 3 to 5. But the report is there that 3 had expired, and not because the legal years of respondent number 3, but they are appearing there respondent number 1 and 2. So I have filed a petition for expunging the name of respondent.
Any objection?
Yes, Lord, in this case, what happened? So far, during pendency of this second appeal, already execution is proceeded. Finally, it's what order was passed for execution. Everything has been done. The amount has been deposited. For execution, the magistrate has been deputed, and that has completed. And that's why, my Lord, the lordship was I have filed down in this context. Now, my Lord,
Execution is over.
yes, this is I have only.
So क्या होगा? Execution होगा तो क्या होगा?
Now, think, my Lord, he is not admitted as it. Yes.
तो execution हो गया इसलिए हम admit नहीं करेंगे तो ऐसा नहीं होगा ना?
No, that I am not saying. My duty is to bring all these things and submit this solution.
What was the suit for?
The suit for, my Lord, there is a dispute. Thing is that the land was belonging to the family members, and that was already firstly filed partition suit. That was decided as a compromise. Subsequently, one of the respondent being agreed, filed appeal, and that was also decided as a compromise.
आप अभी आइए में क्या बोल रहे हैं आप?
हम कहना क्या सर? That हम कहना चाह रहे हैं.
लिमिटेशन का नोटिस हुआ था वो जो 169 दिन का
लिमिटेशन हमें हम अभी लिमिटेशन क्योंकि सब्सिक्वेंटली मैं
पहले तो ये जो बोल रहे हैं डिलीट करने के लिए, इसके बारे में आपको क्या बोलना है?
उसमें पूरे होते हैं.
हाँ तो पहले उसको
केवल हम ऑर्डर 41 रूल 5 में जो फाइल की उसमें आपका ऑब्जेक्शन है, उसमें हम पिटीशन फाइल किया. सेकंड अपील नाउ नॉट सर्वाइविंग वैल्यू एज पर माय व्यू बिकॉज़ that is already execution case has been completed.
But the property is not as such that somebody has consumed it.
That is not there.
you have filed 4388 of 25.
Yes.
What is your prayer?
Look, for expunging the name of respondent number 3.
For what? Why?
Look, C had expired, Lord, and Lord, her legal years are already appearing, Lord. They are respondent number 1 and 2. They have appeared, Lord.
देखिए, IA number 4388 of 2025, the learned counsel for the appellant has submitted that this petition has been filed for expunging the name of respondent number 3
Yes.
from the cause title, as she has expired and her legal years, that is respondent number 1 and 2, are already on record. Counsel for the respondents has no serious objection so far as prayer in connection with IA number, prayer for deletion of name of respondent number 3 is concerned. Considering the submissions, the IA number 4388 of 25 is hereby allowed. The counsel for the appellant is directed to delete the name of respondent number 3 from the constant in writing during the course of the
Lord, now the service of notice is complete, Lord. Respondent number 1 and 2 has appeared, and respondent number 4 has also appeared. Lord, service to respondent number 5 is there, Lord.
सबका हो गया?
सबका हो.
5 नंबर?
Lord, 5 नंबर आए नहीं हैं लेकिन उनको सर्विस है.
सर हो गया. तो अब क्या है? बताइए.
Lord,
Substantial
notice was issued
question of
on
law.
limitation.
हाँ?
Notice was issued on limitation petition.
आप लोग हैं?
169 दिन का डिले.
क्या रीजन?
The reason is that
आइए नंबर.
Lord, IA number 8201. 8201 of 2017.
बताइए. This is section
In
5.
para 6, Lord, I have given the reasons. Lord, the appellant is a very poor and completely illiterate person. He has only daughters. Lord, he is a aged person as well. Lord. So these are the reasons, and he was suffering from piles. Lord. So, Lord, this delay happened.
क्या बोलना है आपको? देखिए आइए नंबर 8201 of 2017. The learned counsel for the appellant has submitted that the petition is barred by limitation by 169 days. He has referred to paragraph 6 of the limitation petition to submit that the appellant is a person residing in a remote village within the district of Gumla and has no regular and independent source of income and is a very weak person and under treatment for various diseases. He has also submitted that the delay in filing the appeal is not intentional. Counsel for the respondents has no serious objection so far as petition for termination of delay is concerned. After hearing the counsel for the parties and being satisfied with the cause shown, the delay in filing the second appeal is irrelevant. बताइए.
There is a petition for a stay.
Stay नहीं होता है. अब अपना बहस करिए. Second appeal है ना? Substantial question of law बना है? बना है कि नहीं?
नहीं बना.
इसी में
नहीं बना है. तो अभी तो आपका एडमिट नहीं हुआ केस.
नहीं हुआ.
बहुत अच्छी बात है. कब का है ये? 2017 से अब तक आपको होश ही नहीं है एडमिट कराने.
इस केस का रिकॉर्ड शायद हो गया था, तो फिर से रिकंस्ट्रक्ट.
केस का रिकॉर्ड हो जाएगा तो आपका रिकॉर्ड तो नहीं घूमेगा ना. इतना दिन से केस लिस्ट में नहीं आ रहा है तो किसको होश में आना चाहिए? इसलिए आपने कुछ होश नहीं लिया इसलिए केस रिकॉर्ड गुम हो गया. बताइए क्या बोलना है.
Case is not that I have purchased a plot of land of 5 decimals from respondent number 4. But the facts of this case is that father of respondent number 4 had filed a partition suit in 1993. Lord, that partition suit.
Office is directed to place this case under appropriate heading on next Tuesday. आपका आएगा ऑर्डर, उसमें फिक्स करना पड़ेगा ना डेट आएगा.
In the next
Tuesday. Substantial question of law में हम अच्छे से सुनते हैं इसलिए तैयार हो जाइए. Concurrent finding है कि reversal?
नहीं
Concurrent है ना.
I can take second appeal 269 of 2019.
सब अपना कैरी ऑन कर लीजिए. आप करेक्शन सब बाद में फाइल नहीं मिलेगा. Order dated 22 June 2020. Essay number 269 of 2019. The learned counsel for the appellant has submitted that a petition has been filed for modification of order dated 22/6/23 passed by coordinating bench. She submits that the matter be placed before appropriate bench. Considering the submissions that this matter be placed before Honorable Mr. before appropriate bench who has passed the order dated 22/6/2023 after taking due permission from the concerned Honorable Judge.
Item 11, first appeal 43 of 2020.
While order dated 7/1/2025 notices were issued to respondent number 5 to speak. It has been validly served.
तो ये ऑर्डर में क्यों लगा दिया? रिस्पॉन्ड नंबर 7 कौन है? सर्व्ड है।
सर मैं उसमें रिस्पोंडेंट नंबर 7 की तरफ से हम हलफनामा फाइल
कब कर देंगे?
विदिन 1 टाइम after 1 you have to 1 to 4.
कितना आप टाइम लगा रहे हैं? यस
रिस्पोंडेंट नंबर 7 बाद में ऐड हुए हैं
नहीं तो पहले से ही चल रहा है।
पिटीशन अलाउ हुआ था
देखिए FA नंबर 43 ऑफ 2020 मिस्टर नाम बताइए।
संतोष कुमार ऑन बिहाफ ऑफ मिस्टर आलोक
मिस्टर आलोक का आपका नाम मिल जाएगा तो आप गलतनामा नहीं फाइल कर पाइएगा।
पैनल में हुई है
मिस्टर नाम बताइए, पूरा नाम बताइए। संतोष कुमार एसोसिएट काउंसिल ऑफ मिस्टर आलोक लाल has undertaken to file wakalatnama on behalf of respondent number 6.
7.
Respondent number 7 within a period of 1 week. As per the office note, the notice upon respondent number 5 has been served through speed post and respondent number 1 to 4 have already appeared. Further, respondent number 6 has also been served. And this service of notice is complete. Post this case on 8th of July.
Item 12, first appeal 71 of 2024.
कितना दिन?
Similarly, other cases
कितना दिन?
618 days
और फर्स्ट अपील क्या है?
against our
FA number 71 of 24 with IA number 4179 of 2025. Let notice be issued upon the respondents both in the first appeal as well as the petition seeking prolongation of delay, for which requisite under ordinary process be filed within a period of 1 week from today. Let the records be called for from the concerned court. Close this case on 9th of July. Let this order be communicated through fax. बस आप काम कर देंगे, ठीक है? दोनों में कर देंगे, फर्स्ट अपील में भी और आई में।